Hey, Kevin.
Hello, Rebecca.
So what are we doing right now?
Look, sounds like this is a Readathon.
Sure is. So, Kevin, before we talk about what happened in the Karen Read case, I watched a hearing today in the case. We're going to talk about what happened there. I just want to mention something.
Mm-hmm.
Do you know who Penelope McGee is?
Penelope, is this the socialite murderess or something like that?
Yes.
I only know that because we just recorded the after show. So on Monday, everyone's going to get to hear Rebecca's hot takes on this case in which a woman was charged with murder after having an argument with her ex-husband, and he dropped dead of a heart attack.
Yes, she was charged with manslaughter by who, Kevin?
By the Norfolk County District Attorney's Office.
Yes.
And the case was tried in front of
Bev Cannone.
Bev Cannone,
as a bench trial, yes.
So we'll let that. We won't spoil that.
All right. So there was a hearing in the Karen Read case today addressing several issues. Would you like me to tell you about it?
Please.
All right.
So many outstanding issues.
There are so many outstanding issues. You're not wrong. So you know who Judge Bev Cannone is?
Yeah. Well,
it was a joke.
Judge Bev, yes.
Do you remember who Richard Green is?
Richard Green. Is he from ARC? No, I don't.
He is the defense's cell phone data expert.
Okay.
Who has asserted that he's sure that Jen McCabe searched Has Long to Die in Snow at 2:34 in the morning.
Mm-hmm. Yeah,
okay?
very important if that's the case.
It's critical if that's the case. So the Commonwealth submitted a filing to try to exclude him as a witness in the next trial, saying that basically he was unqualified, that his data was based on conspiracy theories, all these nutty things, right? In the rebuttal, Richard Green had his own affidavit, which made some really astonishing statements, including that he believed that the data had been manipulated after it was extracted from Jen McCabe's phone. Anyway, so the first thing that Judge Bev talked about at the hearing today was that Richard Green controversy.
Okay.
And it was very short. She said, I'm going to open the hearing by denying the exclusion of Richard Green. She said, it's opinion, which is exactly what Karen Read's attorney said.
Yes, right. It's up for the jury to decide whether it's credible. Yeah, okay.
Right. So Richard Green is in. The next motion to come up was spicy. This is about the reimbursement of expenses requested by the defense. Do you remember what this motion is about? Yeah,
this was about how they had an expert go to the Canton Police Department to retrieve some video and other digital stuff, and when they got there, they said they didn't have it, even though they were supposed to have it. But anyway, this person came a long way, and now they were asking to be reimbursed for this person's time, but it was also a vehicle to get all this information on the public record about, again, another shady thing from the Canton Police Department.
Correct. And after that, or around that time, you might remember that the Commonwealth disclosed in one of their disclosure packages, there was a new video that came out of Brian Higgins, the ATF agent who was present at 34 Fairview and then mysteriously went to the Canton Police Station for some reason in the middle of the night, pacing outside the Sallyport and talking on his cell phone. So that was another snippet of Sallyport video that was then given to the defense. Okay, so this reimbursement of expense motion came up, and Alan Jackson was arguing today.
Okay.
Attorney Alan Jackson from California, who now has a beard, by the way.
Oh, all right. Yeah.
He looks great. So basically,
enough time has passed.
Correct. Jackson spent a lot of time in his argument for this motion arguing the importance of the Sallyport video. So he basically said, we sent our expert there. The money came out of Karen Read's pocket. It was about $13,000 for time, travel, etc. And that basically, they deserve that money back because the state had to have known that the video wasn't there on the DVR. Okay. And then Cannone let him, and I was really impressed with this actually, argue about why this was so important, which gave him the opportunity to A, talk about the new Sallyport video featuring Brian Higgins, during which he said that Brian Higgins perjured himself in front of the federal grand jury. Brian Higgins never mentioned making any phone calls, but apparently denied that he had made any phone calls in front of the federal grand jury. Right. Because they saw him on the phone. It'd be great if a
federal prosecutor said that, but it's okay. Yeah.
Right. And one thing that's important to know is that the defense did file a motion requesting an extraction of Brian Higgins' phone.
And what happened to that phone before they were able to get it?
Well, first of all, the motion was denied. But as those letters were going out telling people to preserve their phones, he was going to get one too. This was earlier. Remember, you have to preserve your stuff. He took apart his phone, threw the SIM card in one dumpster at a military base, and threw the phone in another dumpster at a military base, right? So this is that guy.
And called him on it. That was incredible. Yeah.
It was incredible. So now we know maybe why, aside from texts, he was interested in that phone disappearing. You never know, right? So basically, she gave Jackson the latitude to talk about the expense thing and then give a very detailed, and I wish they had done it at trial and closing arguments, take on all of the stuff around video that has happened since this case began.
Okay.
So back in 2022, in February of 2022, so a full 3 years ago, they filed a motion in Stoughton District Court where the case was at that time. The motion was approved that the state had to preserve all evidence, including video, in this case. All right. So Alan Jackson basically said, A, they had to preserve it. They didn't. Another thing that he said happened was that when his expert went to the Canton police station, somebody subsequently told the DA, Hank Brennan, the fake DA, I'm sorry, I'm calling him that because he's a substitute DA, that a former employee of the Canton Police Department told Hank Brennan that they had downloaded Sallyport video and then uploaded it to, quote, an iCloud account.
Okay.
And Alan Jackson was like,
iCloud
we've
account.
never been told about the iCloud account. We've never had access to the iCloud account. And if that video exists, it is Brady material that has been withheld from us. Alan Jackson also made this incredibly cogent argument about the snippets of video that have come the defense's way. There was some video with missing footage from the Sallyport that came their way on the eve of trial, like right as the trial began. That's the video that shows some Sallyport footage, except for the critical time where Karen Reed's car is being brought in. So that was one snippet. Another snippet, which the defense didn't even know about until trial, it was disclosed in the middle of trial, was that very famous inverted Sallyport footage. And now with the leak of the new piece of footage coming out, or the disclosure of the new piece of footage, Jackson is saying, you have the video. This footage has to be coming from somewhere. You can't tell us the video is gone. And if it is gone, and you do have all these snippets, you never gave those to us either. This is Brady. Okay? So he made this incredible, cogent, very strong argument.
Can I just ask, with that, did he also make a motion to dismiss the charges, or is that...
That is coming.
Okay, that's coming.
I will talk about that in a minute. All right. So then Hank Brennan has his opportunity to get up and rebut.
DA.
Right? Hank Brennan refuses to acknowledge any of the ignored requests by the defense for video throughout the entire proceeding, including by the defense expert Richard Green, who requested videos forever and didn't get them. He ignored that. He basically said, Jackson is crying, violation of due process, which is not a litigation strategy.
Okay.
And he is basically separating on purpose the two issues of whether or not we should reimburse expenses and whether or not we are withholding things and it's a Brady violation.
Okay, I can see the argument there. Yeah, sure.
He basically said you're allowing him in this argument to conflate these two issues, right?
Yeah.
And
he doesn't want that. He doesn't want this getting on the record. Because again, this is all new stuff we keep hearing.
And what's very interesting was that he finished, and Bev Cannone says, Mr. Jackson, is there anything you'd like to add? Which I'm sure is process. But it gave Jackson the opportunity to get up again and say, these issues are inexorably tied together. Because the reason we believed our expert would be valuable in Karen Reed's defense was because of the exculpatory nature of the video that the prosecution led us to believe was at that police station. All right. So he got to say it again, which was amazing. Brennan basically said, we didn't mislead you. Jackson was able to say, of course we were misled. All we've gotten is, quote, scraps from this video. And we were given the indication that the video was present at the police station.
And by scraps, you mean like some still photos or some bits?
Yeah, the bits of the Sallyport thing with the missing footage.
That verify there once was video.
Correct.
And that someone pulled that off of the original video.
Right.
And now that video is gone.
Right.
All that remains are the scraps. Okay.
Right. One of my favorite Hank Brennan quotes is, they're invoking, quote, an injustice that they created. He's basically saying that the defense has created this. He's like sort of leaning on the conspiracy stuff, right? So Bev Cannone actually asked some very interesting questions. I wish she'd asked these kinds of questions at trial, which maybe just isn't the process. But she was basically like, Mr. Brennan, is there more video? Does that exist? Mm-hmm. And he was basically like, there's a drive. I don't know what's on that drive. And she was like, had they requested that you give them that? And he was like, yes, and we plan to comply with it. And Alan Jackson then said, the only reason we haven't done that yet is because I wanted to wait until this motion, because this motion that is tied to this motion, right? Mm-hmm, mm-hmm. Bev Cannone basically said, you get that video to them this week. And if they want to send an expert to watch you get that video off the thing, that's fine. I don't care how it happens. They need that video this week, whatever exists. And Brennan just kept saying, we don't know what's on the drive. Okay. So clearly they have to have somebody with them when they take this video off the drive, right?
To verify they don't fuck with it.
Right. The next issue was kind of a small issue that sounded like a big one. Apparently, the AG's office, when Karen Read's phone was extracted, the AG's office held on to that extraction and data because they were charged with pulling out anything that was attorney-client privilege.
Okay.
All right. So the prosecution filed a motion that they did not have all of the raw data that would have been available to him, but just a report. And I was like, that's what you guys do. You never give raw data, just reports, but whatever. Alan Jackson was like, yeah, we'll give that to them. That's fine. Mm-hmm. So she was like, okay, great, done.
Good.
All right. So basically, here we are, one of two. And she said she would obviously rule on the expense thing at another time, not today.
I just want to tell a fair listener that Rebecca has a whole bunch of handwritten notes in a journal here. So she's just not looking at tweets.
I watched this thing gavel to gavel.
Oh yeah, she took notes. She's flipping. She's got it down. Okay.
Now we're getting to what I believe, besides the Higgins being called out in open court for perjury, what I believe is the most interesting moment, maybe, in this hearing. Mm-hmm. So the next Commonwealth motion was for reciprocal discovery about the ARCA dudes, the two witnesses from ARCA who testified in the Karen Read trial that scientifically proven that she was not hit by a car. Okay, that their science proved that.
Okay.
The state is really picking at this whole concept of ARCA. Now remember, the whole FBI investigation was not allowed to be mentioned at the first trial, but these witnesses magically appeared, and some of the jurors believed they were actually working for Karen Read's insurance company because they were not allowed to say they were working for the FBI.
Yeah, right. Important takeaway in the post-trial interviews with the jurors,
right?
How they perceived that information. Yeah.
So this comes up, and Judge Cannone says, would you like to have a sidebar about this? And they both said, we don't, whatever you want to do, we'll do. We don't care. And she said, quote, I prefer to find out what's going on in federal court at sidebar.
Okay.
So she basically, people on the anti-Karen Read side will say there's no federal investigation. That's a figment of the defense's imagination. Like she basically confirmed once again in open court that there is something going on with the feds.
Obviously.
Yeah.
Obviously.
That was a long-ass sidebar, after which...
That, by the way, is the note. It says, long-ass sidebar, and then a line underneath that. Okay.
Yes. After that, Jackson was like, we intend to comply with all of our obligations. Any discovery you want about these guys is fine. Like, what's interesting, though, is the state actually already fucking has this, because the FBI gave it to them, too.
Ah, okay.
All right. But then... Brennan called them the, quote, so-called ARCA experts.
The so-called ARCA experts,
I'm telling you, this guy is such a douche.
Oh, okay.
He's so, smarmy and unprofessional in certain ways. Mm-hmm. He actually called Alan Jackson's reply to one of his motions embarrassing. He was like, I'm embarrassed. Every time this happens, it's never happened to me in my history. And when it does happen, it's embarrassing. That's what he said. He's just smarmy. He's, Anyway, another fact
Seems
that came
like the
out,
perfect fit for this DA's office.
So at the end of this hearing, there was some housekeeping stuff that they both asked for, and Alan Jackson requested some new dates. Mm-hmm. The defense had been ordered to file their motion to dismiss the case by February 11th. Alan Jackson got up and said, we were just given yesterday a new discovery document that is like a notice of discovery from the state that has 15 categories of stuff on it. And we are certain that this discovery itself is going to work itself into what he described as a, quote, full-throated motion to dismiss.
Wow.
So he asked for more time, basically saying he would love to do it at the beginning of March because, they needed the weekends and stuff to work on it. And Judge Cannone said, I need weekends too, Mr. Jackson, which is actually quite funny. So he repeatedly used that phrase, full-throated motion to dismiss, which I thought was interesting, right? But basically at the end, she ended up shuffling some dates around. They both said they weren't going to have any more evidentiary motions. So she took one of those dates. She said, your motion is now due on the 20th. And we'll have a hearing on it. I believe it's on the 4th, March 4th. Yes. So he has to hand in by the 20th. The Commonwealth has to respond by the 28th, and the hearing on that will be March 4th. And I cannot wait. I cannot wait to read this motion, and I cannot wait to see the response, and I cannot wait for this hearing. But yeah, so basically that was it. And then, the state asked for something and Jackson was like, yeah, no problem. And so there were some new dates. And basically she was like, if there's going to be voir dire of new witnesses, that will happen on the 18th. That's still on the calendar, etc. And then there was one final very long sidebar. So that was today's hearing. What are your thoughts?
Wow. I think that's really interesting. When we're here, we're seeing a different side of Judge Cannone.
In my opinion, we are.
Well, yeah, obviously, my opinion is that she was a little passive during the murder trial and seemed to give, did not seem to give a lot of attention to you might say the conspiracy stuff, but certainly a lot of the assertions of the
misconduct,
defense.
yeah.
Misconduct. And whether that's like the misconduct of the people at Fairview or whether it's the misconduct of police officers or of the prosecutor's office, that's like three different categories. And it seems now she is really looking at at least taking seriously and taking under consideration the machinations of the district attorney's office in relationship to this defense and this defendant.
Yes.
And if they continue to come up with stuff.
Dumb stuff. Let's exclude Richard Green. Dumb, easy enough.
That's the kind of thing. That's not misconduct. You don't win any style points when the judge is like immediately that you never should have brought that up. The defense needs to prove itself to some jurors, but on some points it needs to convince the judge, and they are making progress towards winning these points with the judge. They're moving the ball downfield, to use a Super Bowl analogy here. And so the idea that they have evidence, they're like, we have these artifacts from the video that we were never given. And there just seems to be an awful lot of that stuff that they see that for whatever reason, either it is incompetence or it's willful misdirection and obfuscation on the part of the district attorney's office.
It's the latter. In my opinion.
In your opinion. It doesn't look good. And it certainly gives, why should you be concerned? If you think that Karen Read is guilty, then you ought to be really upset that the people that are charged with doing that are doing so many things that could blow this case for you.
If you believe she's guilty, they're still fucking it up. So one interesting thing that happened at the hearing that I just want to mention is that Jackson seems to have changed his style a little bit from trial.
Okay.
At trial, he was, very aggressive, very showy. He was aggressive and showy today, but he cited a ton of case law that Bev Cannone said she was very familiar with the case, and then she let him cite the whole case anyway. That was regarding the reimbursement. And then he said something really interesting, where when Hank Brennan came up and argued his side of the Canton Police Department expert, he basically kept saying, I have extended the defense every courtesy. Jackson called me and I extended him the courtesy. I said, no problem, blah, 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 blah. In Jackson's rebuttal, he said, it's not a courtesy. It's lawyering. It's the law to disclose everything to us. And that kind of just distillation of this is why this is important is what I was really like praying would happen at the trial and never happened. Like, this is why this is important because of blank. You know what I mean? And granted, he can't speechify in front of the jury all the time, but he did participate in some litigation with these witnesses that I believe distracted the jury and was unnecessary. And if he had just been more direct like he was today in that trial, we could have had a different outcome because it was so clean today, I guess is what I'm trying to say. All right, Kevin, breaking news.
Oh, is that what that record scratch was?
Yes.
Let me put my headphones back on. There we go.
We thought this was over.
This came out while we started recording.
Literally came out while we were recording. Judge Beverly Cannone has denied the motion to reimburse costs and basically says she credits the affidavit of Special Prosecutor Hank Brennan, paragraph 6. Attorney Jack Jackson expressed concern that the materials may no longer exist. Given the time that had passed since the event, I agreed with him and told him I had no knowledge of whether the materials still existed or were overwritten given the passage of time. So basically, she believes Brennan when he says, I thought they might not be there, which is why. So anyway, Karen Reed's not getting her $13 grand back. But that has nothing to do with the Brady stuff.
No.
All right.
It's just the cost.
Boop, ba-doop, ba-doop, ba-doop. That is the end of this breaking news. Anyway, so that's the update from the hearing today. Of course, when that motion to dismiss drops,
full-throated.
We're going to have a full-throated conversation about it. And if anything happens in between, of course, we're going to talk about it.
Of course.
Of
course.
Thank you for joining me so I can once again tell you about everything that's happening in the Karen Reed case.
You got it.
That's what the Readathon's all about.
Partners in Crime Media.